Hello everyone, welcome back to our video updates. It's Sade here. Today's video is going to discuss specifically how a child support lien might affect excess proceeds whenever there's been a foreclosure sale and there is another party listed in the case as a lien holder, and that particular person is listed because of a child support judgment lien. So how does that affect the whole scenario? Of course, as you know, if you've been following this channel or if you've already had some training in other ways, then you know that the excess proceeds are as a result of a foreclosure sale. And a lot of the foreclosure sales do go through a court case. Not all of them do, but if it's going to be a tax foreclosure, which is done by the county's tax office, then it will certainly go through a court case, and you would be able to find a record of it, or at least request a record of that case. So they'll always go through court. They'll go through the normal notification process, and whatever the due process is in that state will be followed, hopefully so. Sometimes they don't do everything just so, but a lot of the times they would have the case filed, and then they would assign an ad litem if they're not able to find the defendant. So that ad litem's job is to try to locate the defendant. If the defendant is deceased, the ad litem is supposed to show that to the court and also try to locate the immediate family members that could be potential heirs that would inherit from that defendant. The ad litem will also look into the probate records and try to figure out whether there was any case open for that deceased owner of that property. And some of the ad litems are better than others. So some of them will do the bare minimum, get paid, and just exit the case. And some of them would actually file reports that are very detailed, and you can find out more information that way. If it's a mortgage foreclosure, it depends on whether that state is a judicial or non-judicial state. Some states are judicial, some states are non-judicial states, and some are mixed. Actually, a lot of them have mixed laws regarding foreclosure. So depending on the type of mortgage foreclosure it is, some of them will go through court and some of them don't have to go through court. So they will do the foreclosure non-judicially. So anyway, regardless of how they do it, sometimes you have liens that are out there against the property owner that owned that property before the foreclosure took place. So what happens when that type of lien is actually due to a child support judgment? What happens when there are excess proceeds after a foreclosure sale and you find out as a locator that there is a child support lien out there against the previous homeowner? Well, the child support liens are always going to be recognized by the trustee or the court, depending on what kind of foreclosure it was. With the mortgage foreclosures, some of them go through court, some of them don't, depending on the laws of the state. And each state has its own law as far as judicial foreclosures or non-judicial foreclosures. And a lot of the states are a hybrid of both. So you will see some mortgage foreclosures going through court, and you'll see some of them not going through court. It just depends on the type of loan and the circumstances. In that scenario, if the trustee does a non-judicial sale, the trustee is not required to notify the other lien holders except for any mortgage liens on there. So of course the child support judgment creditor would not know that a foreclosure had taken place because they actually just filed the judgment just in case, right? So they would not know that the foreclosure took place, and the trustee would not have maybe noticed the child support lien until somebody comes along trying to claim those excess proceeds. So in that scenario, the child support lien will still need to be satisfied because it's owed. It's usually owed to the custodial parent, the parent that's taking care of the children and got a judgment or a court order that said that they were supposed to be getting paid some amount every month, and the second parent basically just abandoned and didn't pay those fees. So sometimes the money is owed to the custodial parent. In some instances, you owe money to the custodial parent as well as to the state, because the state has stepped in as almost a surrogate parent, taking care of those children by allowing them to be on government benefits and things like that. So in that case, there might be a judgment lien for the state. But a lot of the times you see that the judgment creditor is actually the custodial parent. And so you as the locator will have to make a judgment call whether you would represent the previous homeowner or you represent the judgment creditor, the child support judgment creditor, which would be the other parent. And I think your determination would depend on the amount of the excess proceeds that each party might be able to be entitled to, and also how easy it is for you to find either the previous owner or find the custodial parent that has that child support lien. So you make that judgment call. Let's say you have overage of $80,000, for instance, and the child support lien is only for about $30,000 after you add all the interest and all the years that have passed. Then, of course, you can only get $30,000 released to the custodial parent under that judgment. And you'll still have $50,000 that you could collect for the claimant. So in that case, you might want to represent the previous homeowner instead of representing the custodial parent, because you get more because your fees are based on the total amount of overage collected. In the instance where the foreclosure is done by the tax office in a county, then of course, all of the time those ones go through a court proceeding, and the lawyers for the tax office, the lawyers for the county, they already do a lot of good due diligence, and they typically already list that judgment creditor as part of the case. So you'll know right away that there's a child support lien, and then you'll be able to do your math and figure out whether you should go after the lien holder or just go after the previous homeowner as usual. So my suggestion is just to make the call depending on how the math looks and depending on how easy it is for you to skip trace and find either party. Under the laws of most states, or under the law in general, child support liens do not go away. So they would still stay there, and the person that has that judgment is typically the other parent, and sometimes it's going to be the child support office, because maybe they're collecting on behalf of the state because they had to pay a lot of money to support those children because the other parent refused to pay the child support. So the second parent that has the children had to go and get help from the state. So sometimes you'll find judgments for the state, and sometimes it's judgment for the parent, actually. So in any case, what happens when there are excess proceeds whenever the property is foreclosed? So meaning, in this case, meaning that the property of the parent that was supposed to pay, the payor, the person's property was foreclosed on, and there was money left over after the tax office was paid for the back owed taxes. So then what happens with the child support lien? Well, usually the child support lien should have already been included as part of that case. So what I mean by that is that the county's attorneys, for the tax office, they would already have found that there was a lien out there against that property, and it's attached to the property, but it's actually against the person, the parent that refused to pay the child support. So they will find that lien when doing their research, and they would have already included the custodial parent in that lawsuit, because they want to make sure that all parties that have interest or potential interest in that property are notified of the proceeding before the foreclosure takes place. So they actually normally would add the custodial parent into the foreclosure lawsuit ahead of time. Whenever you have non-judicial foreclosures, of course, there will be no requirement for notification. They just go ahead and do the foreclosure, and then that other parent, the custodial parent, might find out later on. And then if that custodial parent finds out later on, what is his or her right in that scenario? Well, the custodial parent that has a valid child support lien against the second parent and has it attached to the property, meaning that it was filed into the property records before the foreclosure date, that party should be able to collect the excess proceeds to the extent of the judgment amount. So let's say the excess proceeds are $80,000, and my judgment, when I add up all the interest and the fees and all the years that have passed, if my judgment was only for $50,000, then I can only claim $50,000 of the remaining excess proceeds. So that is the quick answer to that question. So you as the locator, let's say you're working these cases and you want to figure out what is the best approach. Well, of course, you can certainly represent the custodial parent that has a lien, so that will be a lien holder. You could represent that party, or you could represent the actual claimant if you think there might be some money left after the lien has been satisfied or the funds for the lien have been set aside. So whenever you would represent a claimant in that scenario, even if you've never made contact with the lien holder, the court will not release all of the excess proceeds. They'll set aside the amount to satisfy that lien holder's lien. So that's the way that they would normally do it. The best bet is to figure out who has the higher amount, obviously, and then you can represent that party that has the higher amount in terms of how much of the excess proceeds could you claim for either person, and also how easy is it to find either person. So that would determine who you actually end up approaching in that scenario. So I hope that this video clears it up a little bit. The child support liens will still have to be satisfied as long as they were on record before the foreclosure date. Of course, if you're not able to find the lien holder, then you could still represent the claimant. And so that's my quick answer for you on that particular question. If you have any other questions you'd like us to cover on the channel, remember to drop us a note and let us know. And if you like what you've been seeing on our channel, remember to click the like button, because that keeps us encouraged and allows me to do more videos. And of course, if you like the whole channel itself, make sure to subscribe so that you can continue to get notifications of our new videos. Thank you as always for watching, and I will talk to you next time. Have a great weekend.